Wonk. I kind of enjoy this stuff. I enjoy the machinations of how this happened. So I volunteered to put on today a brief thing here. We're going to look at the 3 constitutional amendments that will be on the ballot November the 3rd. We tried to do this a little bit earlier this year because I know that a lot of you vote by absentee ballot, and we'd like to get some information out before then. It is not my intention on any of these to advocate a position. I'm going to attempt to do it as balanced as I can, but if you have questions or comments, don't hesitate to interrupt me and we'll get you on track. First issue we're looking at today is the drawing of legislative districts. Historically, in Ohio, as in most states, after the census is completed each year or each 10 years by the U.S. government, we're required by federal law to reallocate how our state house and state senate seats are formed. And it's got to be done as nearly as possible on a mathematical model that makes sure that somebody's vote in Columbus, Ohio is worth exactly the same as somebody's votes in Toledo, Ohio, or Somerset, Ohio, or wherever. Historically, there's been a board that has drawn those districts that has been able to do so without regard to a lot of common sense, and they've done so politically instead of fairly. The result is, for instance, today, when probably a slight majority of Ohioans are Democrat, the 33-member Ohio Senate and the 99-member Ohio House are both overwhelmingly Republican. And it doesn't make any difference if I say that today or if I would have been standing here 20 years ago and said that we were slightly Republican and the overwhelming majority were Democrat. Because no matter which party you're talking about, they've all done the same thing as far as gerrymandering these districts to ensure for that 10-year block after the census that their party stays in control. As a result, actually, of a lot of press on this issue, a lot of editorial boards, issue 1 has now hit the ballot. And what it's an attempt to do is an attempt to require bipartisan cooperation in designing how these districts are made. And it's got all kind of technical language in it that, how they have to do those districts. But the reality is what it still comes down to is that there will be a 7-member commission of which the governor, the auditor of state, and secretary of state, and 2 members appointed by the majority party and 2 by the minority party in the General Assembly are appointed. Simple math tells you that it's okay to be skeptical that this will really be bipartisan, because that could mean that there are 5 of one party and 2 of the other party involved in the process. And that's true. It can be that way. What differentiates this from anything we've seen in the past is when the final legislative apportionment plan is done. If there has not been at least 1 vote by a member of the minority party, then the effective period of time that those districts are good for is only a 4-year period. In the event at least 1 member of the minority party goes along with what the majority has proposed, then in that case, we're done for 10 years. It becomes a permanent plan. So although, if you read, and this is what's going to actually be in the ballot in front of you, if you read that, it makes it sound a lot more bipartisan than those of us that are skeptical would think that it's going to be. Okay, any questions on the first and easiest one? Second constitutional amendment. In order to understand the Second Amendment, we got to get to the Third Amendment, and we got to do one or the other first, so we're going to start here. After the people that were in favor of the marijuana proposition started circulating petitions and actually had enough signatures filed with the auditor of state or the Secretary of State to arguably get it on the ballot, although there's some argument about ballot language. The legislature realized that if they didn't do something, this thing was liable to pass, and that they did not feel, the legislature did not feel it would be good for the state. So what they did was pass their own version of a constitutional amendment. As you can read, it would specifically prohibit anybody from granting a monopoly, an oligopoly, or cartel for their exclusive financial benefit, or to establish a preferential tax status. Where have you heard those kind of words before in recent past? Casinos. The first time we saw this kind of thing successfully used was with casinos, and now we're seeing it a second time with marijuana legislation. So our legislature decided that this was something they needed to put a top to. What this legislation would require is once you submit a ballot petition to the Ohio Ballot Board, they have to determine whether it would violate the prohibition against monopoly, oligopoly, or cartel. If it does, then they have to split that petition into 2 votes on the one subject. And the 2 votes are this. 1, should that amendment pass? Fairly obvious. 2, does it create a monopoly, oligopoly, or cartel? Or I'm sorry, should it be allowed to create a monopoly, an oligopoly, or a cartel? Unless both of them are answered in the affirmative, the legislation would fail. So essentially what this is attempting to do is make sure that the public understands that by voting on these issues, they are granting a right to have a monopoly to whoever it is that's applied. The one thing they've done in addition to that, though, and you'll see that towards the bottom of the last full paragraph, is they specifically have addressed the November 3rd election regarding the sale, distribution, and other use of a federally controlled Schedule I substance, in this case marijuana. They've directed this at that to say specifically that if you pass this, then the marijuana issue cannot pass. How do they do that? How can you have 2 things doing exactly the opposite thing on the same ballot? It takes a lawyer to figure that out. Maybe. I'm sorry? Going to tell you that in just a second. There is an anomaly in the law that if you as citizens put a petition on the ballot for a constitutional amendment, after it's approved, it's not effective for 90 days. Not so if the legislature does so. So if the legislature passes, or if this passes, if issue 2 passes, because it's got an effective date prior to the marijuana legalization, the legislature is going to take the position that the marijuana legalization is invalid, simply because the effective date of the ban precedes the allowance. They also put something in there that I don't remember ever seeing before, and that was, Joel, maybe you have in your career, but right out of the box, this election goes immediately to the Ohio Supreme Court if anybody wants to complain about any part of it. So essentially, instead of waiting for 2 or 3 or 4 years to get a decision as to whether or not one controls the other, we would expect a decision within the first year because this matter will go directly to the Supreme Court. Clear as mud? Okay, so we got to redistricting, which ain't the greatest in the world, but it's worth taking a shot at, probably. I'm sorry, I just was biased and I said I wasn't going to. But I was also healthily skeptical about it. And then secondly is the anti-monopoly amendment. Now we get to what everybody's talking about and what you're already seeing advertisements about. Let me tell you first what it does. I'm going to tell you what it doesn't do. And then I'm going to attempt to talk about what arguments the proponents and opponents make. And I want to tell you in the first place, the only advertisements I've seen on this have been about it being a medical marijuana law. It is that, but that's not all it is. And I'll go into some detail here, but this is flat out opening the door Colorado style to the marijuana. Firstly, there are 10 predetermined locations in the state that are authorized to grow, cultivate, and extract the marijuana drug. If you actually look at the legislation itself, we're actually complete with legal descriptions of exactly where those sites are that marijuana can be grown. So obviously somebody already owns that land. The sites will be in Butler, Claremont, Franklin, Hamilton, Licking, Lorain, Lucas, Delaware, Stark, and Summit counties. In addition to that, If those facilities can't grow enough marijuana, after 4 years, the amendment would allow the addition of an extra growth facility, although we don't know where that one would be. This will permit the retail sales of marijuana at approximately 1,100 locations statewide. They're required to be state licensed, but they can only be licensed in a particular location in the event the voters of this precinct authorize a location to be there. So, for instance, just the passage of this would mean that tomorrow we're going to have a location over at the corner of Glick and Dublin Road. There has to be a separate election in which the electorate agrees that it can go in.
Mike, where's the marijuana that's on the street now come from?
Mostly Mexico, the stuff we're getting now. I mean, well, that's right. You get it from Mexico. You get a bunch of Meigs County Gold is still the standard locally. You know, there's a lot of it being grown illegally right here in Ohio, and from Colorado. Well, I submit that's not been established necessarily yet, but maybe. It allows everybody 21 years or older to have up to 8 ounces of marijuana in their possession and to have 4 growing plants, as long as they pay $50 and get a license to do that. 8 ounces is a bunch of marijuana. I don't know personally, but I've been in a courtroom. I have been in a courtroom when they brought these baggies in, and I got an idea. 8 ounces is enough to last you for the next couple days.
Mike,
Yeah.
how do they enforce that?
How do they import it?
Yeah. How do they enforce whether somebody's got 4 plants or 6 plants or 8 plants?
Oh, how do they enforce? I thought you said how they import it. They get the license, and arguably there's going to be a marijuana control board that arguably should have the authority to inspect licensed locations and that kind of stuff. In addition to that, as happens now, a cop comes to visit your residence for something else and sees you got 6 plants, you're in violation of the law. You'll be required to show your permit that you got 4, and if you say, well, that's my wife's, but if she hasn't got a permit, then you got a problem. In addition to those, anybody without a license that's 21 years or older can have up to 1 ounce of marijuana for recreational use and to share. They also authorize the use of medical marijuana by any person regardless of age, as long as they have a certification of a debilitating medical condition. And I'll tell you, I don't know if it's still this way, but as recently as a couple years ago, in this state, cocaine was still being used legally by doctors. They could prescribe it, although not in amounts that, would get you high, but it was like a numbing agent when they'd work on your nostril and stuff like that. They would prohibit marijuana establishments from being within 1,000 feet of a house of worship, library, elementary or secondary school, daycare center, or public playground. However, if you build a church next to a marijuana place, you can't force them out. So they got to be in legally before they get started. They prohibit local zoning laws from prohibiting the manufacture of the marijuana, and they create a special tax rate. Now, what are the pros and cons that people are arguing about this? And I tempted to knock it down to several on each side, actually. In the first place, the biggest critics of those that would say that we should not have a marijuana ban, that we should legalize, is simply that over the last 30 years we've proved extensively that the war on drugs is not being won. That whatever we're doing, it ain't working. We've created violent cartels that are at least equal in strength and violence and evilness to the mafia during the Prohibition. You got to remember, that's where the mafia got their foothold, was when the Prohibition started, and they started manufacturing and selling the alcohol. They argue that we've made criminals of a bunch of people, mostly young, that would otherwise never have had a criminal record. They would make the case that if the cops break into a residence where there's a bunch of people sitting around stoned, the probability of there being violence is a lot less than if they broke into a place, or the cops come into a place where a bunch of people were sitting around drinking. I don't know if most of you know, but most of our domestic violence runs are alcohol fueled. So basically they're saying we're no worse than what, or we're not as bad as the alcohol is. They contend that because of the way the medical marijuana would be dispensed, that it would allow doctors to practice medicine. It does ban driving under the influence or flying under the influence or any of the same kind of stuff we've got with alcohol. It bans anyone under 21 from using other than for medical purposes. It's prohibited on all public land. Now when I say public, I'm not talking about places like this that are private places open to the public, but I mean actually schools, playgrounds, that kind of stuff. Would not affect an employer's ability to regulate the conduct of his employees. And again, every precinct would have to improve the location. Those opposed, which include most organized groups, quite frankly, from bankers to Chamber of Commerce to whoever, contend in the first place that creation of a constitutional monopoly does not make sense. They would argue that it eases and encourages drug use and subsequently addiction because, in fact, marijuana is a gateway drug. They make an argument that regardless of what we do, it's in violation of the federal law, which is going on now in Colorado and Oregon, and apparently the Department of Justice, for whatever reason, has made the decision not to prosecute. And finally, they would point to Colorado's experience and say that it isn't all as good in Colorado as they would have you believe, that there's been a significant increase in people picked up driving under the influence of marijuana, that it has not curtailed the availability and sale of illegal drugs, partly because the cost of going through the process, and these licenses are fairly expensive, plus paying a 15% tax, which the legislation applies, or would apply to it, have simply made the price so high that there remains a very significant illegal market for the cultivation, use, sale of the marijuana. I'd be happy to take any questions.
Mike, these are both